Hello, good morning, good afternoon, good evening, everyone. My name is Guilherme Canela. I'm the Chief of the Freedom of Expression and Safety of Journalists section here in UNESCO headquarters in Paris. It's my great pleasure to moderate this webinar. Thank you so very much for attending, for enrolling, for your interest in this super important topic for us. Apologies for the slight delay in starting it. We were experiencing some technological hiccups, even after all these 529 Zooms that we did in the last 2 years. We still have problems with these things, but nothing that it can't be solved, luckily. I have three fantastic speakers here with me today, speaking from London, Peter Noorlander and Sarah from Media Legal Defense, and speaking from Bogota, Ana Bejarano from El Veinte and Los Andes University. I will tell a little bit more about the three of them when they will speak. But before we start on the actual content, the team here asked me to do some usual housekeeping announcements. So as you can see in the usual interpretation button, the globe you have here in the bottom of your screen, we have interpretation in English, Spanish, and French. So feel free to choose one of your preferable languages. I start already by thanking all the interpreters for their super good and essential services so we can communicate better among each other. Also, please be aware that this event is being recorded and it will be available on video on demand later on. So this is important in case you have any issues with recording. And we want, although we have 1 hour, we want to make this as interactive as possible. So we will start with some kicking off, warming up conversation with our three guests. But the idea is that we will have some Q&A at the end. So if you want during this first part to already start adding your questions in the Q&A facility here in the chat, please do it, and we're more than welcome these discussions. So very briefly, we are here because we have good news and bad news as usual. The good news is the following. UNESCO 10 years ago started a huge initiative that we call the Judges Initiative, and this initiative has involved so far 24,000 judicial operators from 150 countries, most of them judges and prosecutors. And more recently, in another initiative that we call the Global Media Defense Fund, we have been supporting networks of lawyers and others in different countries. This kind of support started 3 years ago, and different networks and more than 1,000 lawyers were already engaged. And these people, these different players and actors, and I guess many of them are connected today, talking to us, they have underlined the good news. The first one is the concrete interest of these judicial operators in this issue, that is how freedom of expression, access to information, safety of journalists can be further protected in the judicial systems while the law is being applied by those judicial operators. And this is not minor at all. I mean, you could see by the numbers, the fact that 24,000 judges and prosecutors are interested in being trained in these issues, are interested in connecting and interacting, and plus the lawyers. I think it's very good news. The other good news is that these judges have been mentioning to us that they are witnessing more and more cases receiving Amicus Curiae when the issue is freedom of expression. And again, this is also good news, the fact that the different relevant stakeholders are using this kind of procedure where in the jurisdictions it is allowed to further protect freedom of expression, to send a concrete message pro freedom of expression in relevant cases worldwide. The bad news is that this is also happening because the misuse of the legal system to attack freedom of expression is growing a lot. Different phenomena such as the SLAPS, as you know, in this Anglo-Saxon acronym for this, but it's basically the misuse of the legal system to attack freedom of expression. More and more cases are reaching the judiciary, and the outcomes of these cases are not necessarily the outcomes we expect. So connecting those two dots, I had many months ago a very interesting discussion with my good friend Peter Nolander here in this call. And I asked him, do you think it's useful if we could produce some guidance for this? Since we have interest, we have demand, and we are already witnessing more and more use of Amicus Curiae in cases related to freedom of expression. Maybe we can provide some sort of guidance for those different players interested in keeping using these or started to initiate this use, and so on and so forth. And Peter agreed with me. I don't know if because he actually believed on that or just because we have a good relationship, but in any case, he accepted the challenge. We produced these guidelines that I guess my team is posting here in the chat for you, that is currently available in all the 6 UN official languages. And if any participants in the call see that it would be useful to also make that available in other languages, UNESCO can gladly consider. So in a nutshell, this is the context. There is appetite in the judicial system for more of these, for receiving more Amicus Curiae. There is appetite on the practitioners to engage with that. And in our case, UNESCO, as the UN organization in charge of protecting and promote freedom of expression, we have the interest to keep developing and supporting these different organizations and these different processes through the development and discussions of tools like this one we are discussing in this webinar. And for that, we also partnered a lot with our dear colleagues from Media Legal Defense, which are beneficiaries of our Global Media Defense Fund, and are, as you know, landmark organization in doing this, in doing media legal defense, in also using this instrument of Amicus. So they were also very involved from the outset in helping us in commenting and circulating, and therefore this joint webinar co-organized by UNESCO and Media Legal Defense, and I thank them very much, all the team there in Media Legal Defense, for this joint organization. So this is the context, and what I suggest here is that we start by Peter, and he could give us an overview of the tool, and then we engage Anna and Saba and just after Peter. So for those who don't know Peter, and Peter, if you allow me, I'm not going to read all your credentials, but Peter is a human rights lawyer who has spent a lot of his professional life in defending journalists and the rights to freedom of expression around the world, working at NGOs, including media defense. He has been at the heart of international campaigns on issues such as the right to information and the ending of imprisonment of journalists for defamation. And he publishes widely on these issues, and he is the author of this document that is kind of animating our discussions today. So Peter, thank you so much for accepting the challenge more than 1 year ago, I guess, but also accepting to speak with us today. So over to you.
Thank you very much for that kind introduction, Guilherme, to speak here today, and also to write the guide last year. You're right, it was last year. You've stressed how you would like this to be interactive, so I'm going to be quite brief, and I'm actually going to time myself so that it won't take too long. I'm going to share my screen. I've got a very short presentation, really just to guide me. It won't be one of those boring presentations, I promise. There's always a slight pause before the person then finds it, and here we go. Got it. Right. You asked me to speak to the guide. Well, this is the guide. It's the UNESCO guide for Amicus Curiae interventions in freedom of expression cases, as you've said. It's on the UNESCO website. It's quite a long URL. It's in the chat. I also created a shorter link to it, and it's available in French, Spanish, Russian, Chinese, and Arabic. And just having it available in all of those languages, I hope will really help making it as usable as possible. What I'm going to talk to you today is three things: what, why, and how. And specifically, what is this Amicus Curiae thing? Why would an organization want to get involved? And how do you write a brief that is truly effective, that hits the mark? So to start with the first question, well, really, I need to back up a little bit and say, you know, what's up with the Latin? So Amicus Curiae is a Latin term. Latin is a language that lawyers learn in order to be able to confuse their clients and show that they've gone to university for 3 years. Amicus Curiae literally means a friend of the court. It's an old legal concept which dates back hundreds of years and which I'm not going to talk to you about now. But in the present day usage, it really denotes an intervention by someone or an organization who is not a party to a case, but who feels that they have something to contribute. And they therefore request permission in the cases where you have to do that, or they, of their own motion, submit a brief to provide their opinion. In some countries and in some jurisdictions, this is referred to as a third-party intervention or some other, description. I and the guide uses Amicus Curiae as a sort of a catch-all term to talk about all of these. Amici Curiae, by the way, is the plural of amicus, and so that's used sometimes when there are multiple organizations intervening in a case. So that's a little bit of a linguistic thing. But the really important thing that I want to get to is strategy, and that is the why that I mentioned. Why would an organization want to do this? There are important potential reasons, and some of them are short-term, some of them are long-term. Longer term, an objective would be, well, you can help change the law in a country for the better by influencing or trying to influence or push the court to come up with a judgment that is going to have the effect that you want it to. There can also be a short-term objective. Perhaps it's a case of a journalist being on trial and you want to show solidarity. There too, you can engage in an Amicus Curiae brief, and there can be other reasons as well. Some of them short-term, some of them long-term. But I think what is important at the outset is to realize why it is that you're doing this. Then to ask yourself, is an amicus intervention actually the right tool to do this? And if the answer then is yes, your objective will also shape the arguments that you are going to bring in your case and the parties that you might want to join in on the intervention as well. What you also need to think about is potential downsides. The case may not be won. There may be a really negative judgment. You also have to bear in mind that you must not do any harm. If you're an international organization and you intervene in a case, that may be seen as foreign intervention. It may politicize the case. It may reflect negatively on the journalist that may be on trial there. And so all of these are reasons that you need to really pause and ask yourself, why are we doing this? And is this the right strategy for us to be pursuing? Then, how, once you've decided that it is the right thing for you to be doing, how do you actually do it? Well, I need to emphasize, first of all, that this is a legal process you're going to get involved in. And if your organization doesn't have lawyers on board, on staff, you're going to need to find lawyers to work with. It's a legal process. You want professionals. If you're not a dentist, you wouldn't engage in dentistry. It's the same thing here. Just don't do it. That means if you don't have lawyers on staff, that you've got to find the right ones. You have to shop around. You need to Find people that understand what you're seeking to achieve and who you feel are on board with you, but who also understand the legal process in the country where the case is going on. There's quite a lot of considerations that go into choosing a case, to choosing a lawyer, sorry. And there's a risk that, sometimes NGOs that aren't used to working with lawyers can be intimidated by that. Don't be. These are, people like you and me, human beings that just use the occasional bit of Latin. The guide includes some pointers and some indications for organizations that can help you with finding lawyers, and Media Defense might be one of those organizations. Then once you have your lawyers, you want to make sure that they're on target. And so this little graphic here shows your lawyers running to submit your case and hitting the target, because that's what you want them to do. In order to hit the target, you have to start with your objective. Why is it that you're submitting this case? And then be as clear as possible in your brief and write the kind of arguments that the court is going to find persuasive. That means that you're going to have to do a little bit of research on the court that you're submitting, that you're intervening before, and make sure that you make arguments that they sort of intuitively are, receptive to. There's a large degree of cultural and political sensitivity that's going to be required in this. In freedom of expression cases, from a legal point of view, it may sometimes be tempting to quote US First Amendment jurisprudence, for example, because they provide very strong protection to freedom of speech. However, if you do that before a country that isn't the US, or in a country that isn't the US, you're going to need to persuade the court why they should, take any account of what the US Supreme Court has said. And there's a certain skill to bringing those arguments that you're going to need to bring into play here. Some courts require you to be objective. They don't want you to, take the same stance as one of the parties in the case. And if that's a requirement, then you need to take it seriously, because this is, you're a guest in these proceedings, and you need to behave accordingly to a degree. However, objectivity does not mean that you cannot take a clear position on points of principle. So if you're arguing on the basis of international human rights law, you can say, well, under international human rights law, the governing principles in this case would be A, B, and C. You don't have to then say, and therefore you must release the journalist, but you can very clearly state these principles while still being objective. What you should also do is think about who's going to be reading your brief in the courts. And often the person that's going to be reading the brief from beginning to end is a clerk who is overworked, who really doesn't want to have to read yet another 30-page document. Often their job is to summarize the arguments made in the brief, and a great way of making sure that they do that well is by providing your own summary, making sure that it hits all the points that you want to hit. It's all about making that you are user-friendly in how you do this. That's effective. What can also be really effective is coalitions, especially coalitions that show that a particular case or issue raises a point that is of concern across, society in a broader sense, and that doesn't just affect journalists, because journalists are not always the most popular people in society. So having a coalition with human rights groups, with environmental groups, children's rights groups can be incredibly powerful. Then finally, and this really is a whirlwind tour, everything that I've spoken about and sort of touched upon is dealt with in detail in the guide itself. So I urge you to look at that as well. But finally, when the case has been won, fingers crossed that it will be won, follow up. Make sure that you have an advocacy strategy and that you engage in the monitoring process on how it's implemented as well. Because at the end of the day, a judgment is just a piece of paper. And what you want to make sure is that it's also that it also becomes reality on the ground. This has been a 10-minute whirlwind tour. I'm going to leave it at that, but I'll be more than happy to answer any questions or go into any of this in more detail later.
Fantastic. Indeed, it was kind of those YouTube videos, how to do an Amicus Curiae in 10 minutes. And look, I really recommend you reading the document, because I already told this to Peter personally. The likelihood of having these legal documents in a very boring way is super high, because it is the way it is the taxonomy of the legal professional, etc. But Peter did manage to produce this guidance in a way that is actually a pleasure to read. So I would strongly recommend, for the more than 100 plus people connected, if you haven't done it yet, you will really see all these tips in a way that is further developing the guidance. And please email us if you have good experiences, if you think you should share things that eventually, if you are updating this guidance, we should take into consideration. And Peter, there are already some questions in the Q&A, technical questions about the Amicus. You might consider to start looking into them. So now, let me turn to Ana Bejarano, and Ana, I understand she will be speaking in Spanish. So for those who needs the interpretation, please start looking into your Spanish, English, French button of interpretation. Ana, as I said, is based in Bogota. She's the co-director of El 20, which is a Colombian group of legal professionals, journalists, and human rights defenders convinced of the importance of freedom of expression for democracy. She has a law degree from the Universidad de los Andes, as well as a Master of Laws from Harvard University. She's currently a professor of procedural law and academic director of the Judicial Training Program at the University of de los Andes. She's also a litigator and pro bono coordinator of Bejarano Abogados, a boutique law firm in Bogotá. Ana, muy buenos días para ti allí en el otro lado del Atlántico, y por favor, adelante.
Muchas gracias, Guilherme, a la UNESCO por esta invitación y a los copanelistas. Es un gusto compartir este rato con ustedes. Decidí hablar en español para de pronto tener más fluidez. Espero que para todo el mundo esté bien. Voy a tratar de hacerlo en español lento, no en español colombiano, que de pronto a veces no se entiende. Me parece muy interesante entonces la introducción práctica que hace Peter sobre cómo presentar un Amicus Curiae, cuál es el origen etimológico de esa concepción, de ese latinazgo que utilizamos los practicantes jurídicos. Y en esta ocasión, también solo por 10 minutos para no aburrirlos demasiado, voy a hablar sobre la historia del Amicus Curiae y la relevancia constitucional del Amicus Curiae en el sistema judicial colombiano, que creo que además habla mucho también del panorama en América Latina, y unos retos que creo que podríamos, a raíz de empezar estas conversaciones internacionales que me parecen tan importantes, empezar a traer elementos que resultan eficientes y efectivos para promover las causas de la libertad de expresión ante las cortes y también, por supuesto, ante los juzgados de primera instancia, donde se litiga mucho de ello de manera importante. Entonces, con la Constitución de 1991, en el 1991 hubo un cambio constitucional en Colombia que realmente revolucionó todo el sistema legal. Y lo modernizó, y también empezó a tomar elementos del constitucionalismo moderno que en los 90 se instaló en buena parte del sur global. Lo que ocurrió fue también que, como ocurre con todas las transiciones y traslapos de instituciones legales, realmente se copiaron algunas cosas, pero no todas. Entonces se abre por primera vez la Corte Constitucional. Ya existía, por supuesto, las funciones del juicio de constitucionalidad a cargo de otra corte, que era la Corte Suprema de Justicia, pero en el 91 se crea solo una corte para revisar las demandas de derechos fundamentales de naturaleza constitucional y también la revisión de las leyes. En ese proceso, entonces, la primera vez que la Corte Constitucional, y esto es una hermosa coincidencia, pero ahorita en Colombia están hablando sobre la despenalización del incesto, del delito de incesto. La primera vez que la Corte invita amigos de la Corte para poder nutrir su decisión es cuando revisa la decisión del incesto en 1998. Se demanda la prohibición legal del incesto para una sociedad colombiana que es profundamente creyente, católica y conservadora en términos de libertades individuales. Esta demanda representaba un hito político para la Corte, que había venido despenalizando ciertas conductas, el consumo mínimo de drogas, la eutanasia, había hecho ciertas decisiones en términos de libertades individuales, y llega la demanda del incesto y la Corte dice: no queremos decidir esto solamente los jueces de la Corte Constitucional, esto es un problema antropológico social mucho más amplio. Y entonces
Constitutional Court in Colombia have decided that they can't decide on their own on this incest issue, so they decided to invite many experts of different fields to debate on this topic. And finally, the Constitutional Court decided that it would still be a criminal offense, that incest would still be a criminal offense based on the advice received from the Amicus Curiae system. So I think that it was then that the Constitutional Court understood which were the three main benefits, and I would like to talk about them now. The first benefit was to understand that there are specific processes, and this applies also to freedom of expression cases, that will have political consequences because these cases somehow interact with other institutions, or because we are dealing with historically discriminated groups, or because they have to do with a specific profession that is vital for our democracies and the well-function of our democracies. So this means that it is not only a constitutional issue, but also a political issue. And it's the first time that judges in the Constitutional Court understand something like this. It's a huge leap for our system. The second benefit of the Amicus Curiae system, and it also applies to freedom of expression cases, is that comparing rules is not enough to come up with good solutions. We also need to take into account other types of knowledge and other approaches to study a very complex issue such as incest. So the Constitutional Court back then said, for example, well, we don't know what are the consequences, genetically speaking, for example, of two siblings having a child. We don't know about consequences in other spheres. And so they realized back then that they had to incorporate experts from other fields in their constitutional dealings. This might seem obvious to us now, but it was really a breakthrough, because judges in the Constitutional Court realized that they might not know everything they needed to know to make a decision, and had to invite experts from other fields. And then the third benefit is to bring to the table experts on a specific issue to deal with a specific topic. And this is something very important. For example, sometimes we invite international organizations. For example, there are cases in Colombia against journalists, against freedom of expression. The fact that there are international organizations that tell us that this is a specific pattern that we are witnessing in many countries where the judicial system is used against freedom of expression. This allows the Constitutional Court to understand what the problem is, and that this is not something that solely affects our system. In fact, this exists elsewhere, and this allows the Constitutional Court to make the right decision. And this has led to what in Colombia is known as the constitutional dialogue. It was thanks to Amicus Curiae, and it basically means that there is a dialogue between the constitutional court and the community, the society, who wishes to expand its rights. So we would prefer for Amicus Curiae to be taken fully into account in cases of freedom of expression, because this doesn't have any financial consequences, for example, for journalists, and because it allows to compare two different constitutional values, for example, the right to information and dignity at the same time. So this constitutional conversation or dialogue means that now we are seeing different types of defense in these freedom of expression cases. And it is the Constitutional Court which decides in the end on these cases. For us, well, there are two things to take into account. On the one hand, we sometimes promote Amicus Curiae, but now we're going to change the way we work to include all its elements. Maybe we should not write at length, because sometimes we have a clerk that has to summarize 20 pages, which is what we send them. So maybe it's easier if we send shorter documents. But basically, when we act as amicus, as a friend of the court, it's different than when we are one of the parts in a case. So it's a different figure, a new figure. And another thing I would like to mention is that I hope that this constitutional dialogue that has helped so much freedom of expression cases, both in my country and many other countries in Latin America, like Argentina and even Venezuela, some 10 years ago. In Peru also. So in these countries where society is going through tense situations, I think that it's even more important that the judiciary includes freedom of expression considerations. And the problem is that in the lowest courts, many believe that this is something they shouldn't take into account. However, we have this figure of Amicus Curiae that not only applies to the higher instances, but also to lower courts. So we hope and we want for these lower courts to listen to outside voices, to the Amicus Curiae, to achieve different solutions. So we hope that the Amicus Curiae can create a broader freedom of expression conversation in society, also in my country, in Colombia, because in my country, lower courts are not taking into account freedom of expression standards at Latin American level. So the higher courts need to reverse their conclusions, which leads in many cases to censorship at the beginning. This is all I want to share for the time being. Thank you very much.
Thank you very much for that. And I think it's very interesting for those connected that are not aware that the Constitutional Court of Colombia is a kind of a good practice in many of those different areas. Actually, if I'm not mistaken, but maybe Peter and Anna and Saba can correct me later on. What Anna was explaining goes even beyond the particular definition of Amicus Curiae that Peter was explaining before, because the Constitutional Court of Colombia opened even for a broader kind of participation, inviting public hearings, which is even it's a step forward compared with the possibility of presenting actually a file on a particular case. And it's interesting because other courts in different parts of the world are expanding this possibility in a similar way. So then that particular item in Peter's PowerPoint, that you need to have a lawyer to participate, it's not necessarily the case when the court is inviting experts that are outside of the legal profession to participate in public hearings on different ones. I think this is a very interesting discussion because it's an expansion of the concept of what would be the people providing elements to the courts to take a better decision. And I would strongly recommend for those who are not aware to have a look in the decisions on freedom of expression of the Constitutional Court of Colombia, because they have actually expanded a lot in different cases the freedom of expression in the country. Maybe the UNESCO team here can post the link to the Columbia database on different cases of freedom of expression. You have this available now in several languages, and if I'm not mistaken, several of the landmark cases of the Constitutional Court of Colombia are included in the database, and many others. No? So Saba, now over to you. Media, I guess you will explain that media defense has been actually doing that, presenting Amicus Curiae in different parts of the world, and aside of defending journalists, not only as amicus, but as the main legal team of several of these journalists and other freedom of expression defenders, etc. So, and you are a main partner of us in this discussion. I would give the floor to you to go and underline those areas, just to let our audience here to know. Saba is the senior legal officer at Media Defense. She qualified as a solicitor in 2013 and joined Media Defense in 2018. And that Media Defense works on strategic litigation and emergency defense cases concerning freedom of expression. She has assisted in filing cases before both regional and international mechanisms. So, dear Saba, over to you.
Thank you so much, Guilherme, and thank you everyone for joining what is a really interesting discussion at the moment. I think I'd like to thank Peter's kind of overview, because I think it really kind of contextualizes interventions, third-party interventions, and sets the theme, and also to Anna to provide the benefits of having those interventions come out of Colombia and then more kind of broadly in Latin America. As mentioned in the intro, I'm one of the lawyers working for Media Defense, and our core mission is obviously to ensure the legal protection of journalists and independent media who come under threat for reporting on issues of public interest. And as part of our work, we regularly intervene in cases where freedom of expression principles are being examined by the courts. So I thought it'd be interesting just to take the next few minutes or so to provide some insight into how we decide on which cases to intervene in and how we develop those interventions. So I think it was mentioned by Peter when he was talking in his overview, what are some of the considerations, or what are some of the thoughts that you should think about when intervening within a case. And for us, one of our main considerations is to ensure that we're able to provide the court that we're intervening at with something of value. So in other words, our intervention needs to kind of contribute to the court's understanding of the case. So we work obviously globally, so we intervene in wherever there's an opportunity to do so. But a lot of our interventions, I guess the focus of my contributions will probably be at the European Court level. So we regularly intervene in cases that deal with freedom of expression issues coming out of the European Court of Human Rights. So when we are submitting those kind of interventions, we would need to ensure that we're able to provide, an analysis perhaps of international comparative law from another jurisdiction or another region. So, for example, we can take concepts and principles that have been developed as being talked about by Anna from perhaps the Inter-America system, other common law jurisdictions, or even, what other countries are doing within the Council of Europe member states as well. I guess one of the other considerations that we think about when we're looking to intervene in a case or not is to make sure that we address issues that are relevant to our mandate. So for us at Media Defence, we need to ensure that the intervention addresses press freedom or journalistic activities or practices. So often courts, and I think this was mentioned in Peter's presentation, this is definitely the case at the European Court of Human Rights, they note when they are granting you leave to intervene that your submissions shouldn't include any comments on the facts or merits of the case, but should only really kind of address general principles that are applicable to the determination of the case. So for us, we need to kind of look more broadly at the principles through our mandate to see how best we can provide the court with information on those standards. So perhaps I can take the next few minutes just to give some examples of cases where Media Defence has intervened, and just to kind of give an idea that sometimes our interventions have been in instances or in cases where there are relatively uncontroversial issues that are being examined by the court, but it's still important to highlight certain principles that are being raised through an intervention. So this, for example, happened in a series of Turkish cases post-coup in 2016, where many journalists were being imprisoned for their journalistic activities. And despite the law not being, very novel, aside from perhaps one of the arguments around Article 18 of the Convention, the main basis of intervening within those cases was to submit comments with a coalition of interveners in order to bring to the court's attention that what was happening in Turkey was a real issue of concern to freedom of expression organisations. So Media Defence intervened in those cases and led a coalition in terms of drafting those third-party submissions and submitted those to the court. In other instances, where, for example, Media Defence might be representing an applicant, and this has happened again in another Turkish case, we've actually prompted organisations to intervene in the case. In that Turkish case, the issue being considered there was one of whether the domestic legal system was functioning properly, because there were so many delays. And as a result, it was causing massive bottlenecks and cases weren't considered in a timely manner. But obviously there are kind of other instances where Media Defence has intervened in cases which do really raise quite contentious issues on freedom of expression principles that remain unresolved. And often our hope is that our intervention is able to provide the court with a different perspective. And in those cases, given the issues that are being raised remain to be settled by the courts, it can normally be slightly difficult to provide a line of case law that is useful when making your point about that issue that you want to address. So it can require a little bit more thought on how you would actually angle those interventions and what those interventions will look like. So, for example, in 2021, Media Defence intervened in a case before the European Court of Human Rights, which was considering whistleblower protection in the context of the LuxLeak papers. Specifically, that was a case that related to an individual who was criminally sanctioned for leaking documents that was already in the public domain. And it's a Grand Chamber case in which there was a hearing last year, and actually we understand the court's looking to give its judgment next week. So the applicant in that case was convicted on several charges, including theft, breach of professional secrecy, and they were fined. And the European Court's lower chamber's decision held that the criminal conviction, was compatible with the right to freedom of expression, and found that the domestic courts had kind of carried out the appropriate balancing exercise between the harm that was caused to the company, in this case it was PricewaterhouseCoopers and the applicant's right to freedom of expression. One of the other things that was quite interesting about that judgment was the fact that the Chamber's decision looked at the fact that the information that was coming out the disclosed documents didn't really contain information that was new, essential, or unknown. And that was a real kind of legitimate kind of consideration in their analysis of that case. So when Media Defence was looking to intervene in that, we looked at Article 10 from a slightly different perspective. And our intervention focused on kind of two aspects. One, which was looking at the news gathering activities of investigative journalists. And two, kind of noting that the editorial decision about the contents of reporting are matters really for the media, and they're generally better placed than, for example, the courts. And that's something that, you know, the European Court jurisprudence coming out of the European Court has kind of emphasised this second point, that journalists should really enjoy the freedom to choose which news items come into their attention and how they will deal with that and how they'll report it. So as such, you know, any information that's already in the public domain may take on a different meaning, you know, if that context has changed. And that was kind of what we were looking and raised in our intervention. And we're very much looking forward to seeing how the Grand Chamber deals with that case in its decision, hopefully next week. I just want to talk about one last case, because I know that we want to kind of leave some time to have an interactive discussion. But I think at the beginning of last year, we Media Defence intervened in another kind of very kind of topical case that was raising some real live issues at the moment that's being considered. And that's a case concerning the liability of third-party comments online, which raises, you know, these issues of regulation of the internet. So this is very much a live topic for those that are, you know, within freedom of expression circles, and many of those that might even be joining this webinar be aware of kind of cases that are going on in the US at the moment that are looking at, you know, platforms and online intermediaries, and whether they should be held for committing acts of, in the US cases, acts of aiding and abetting international terrorism through user-generated content on their platform. But the case that that Media Defence actually intervened in before the Grand Chamber of the European Court was in relation to an applicant, an individual who was a politician and was charged with the offence of incitement to hatred following comments posted on the wall of his Facebook account by a third party. The lower chamber found that there was no violation of the applicant's rights, Article 10 rights. But our position when we looked at this and we submitted a third party intervention was that the lower chamber's decision, when they were applying the principles from a case of Delphi, which was the first case in 2015, which looked at online intermediary, were not applicable in this case. We were able to distinguish the two. And for us, we were, you know, we said that in the Delphi case, which was in relation to a much bigger kind of internet news outlet who worked on a profit, had much larger resources and capacity, that was very different to, for example, an individual whose personal Facebook account is being, you know, considered to be an intermediary for the basis of this decision. So in our view, we think, you know, we thought that the lower chamber got that decision wrong. And there was a very good dissent in that judgment, which we actually kind of agree with. So we were able to use that when we were submitting our intervention to kind of distinguish the Delphi cases. But again, you know, as mentioning earlier, we have to be very careful not to speak about the facts of the case specifically. So you have to be quite subtle in how you're going to present that argument within an intervention. I mean, at the European Court, they stipulate the kind of length of the interventions to be 10 pages. So you're very much limited to page numbers and in how you're presenting your arguments. So for us, we're saying that the Grand Chamber is now considering factual circumstances that happened 10 years ago. this situation happened in, I think it was 2012, 2013. And you're now, and it's dealing with a criminal prosecution of an individual. And for us, the context of ensuring the certainty of criminal sanctions, you can now see it's a potential problem for the Grand Chamber to consider those facts 10 years later, especially given this is a contentious area and one where there's evolving technological developments. So, there were a lot of issues in that case for us that were very interesting, and it raised concerns about the imposition of liability for social media users, which is seriously going to obviously impact for, human rights defenders, journalists, civil society actors, especially those that are, using this platform to disseminate public interest information in circumstances where no other channel, so, the lack of independent media is open to them. And we're really looking forward to seeing how the court grapples with some of those issues that are being raised in that case and in our intervention. I'm going to cut short my contribution because I do think that it'd be really good to kind of have a bit more of a Q&A and interactive discussion, but hopefully that kind of gives you a little bit of an insight of what media defence's kind of thinking is when we're looking to intervene in cases. But yeah, I'm happy to kind of speak more to that if we have some time later. Thank you so much.
Thank you, Saba. That's very interesting and also very complementary with the different discussions. So Peter started with a broader overview of the concept of Amicus. What are the key elements to take into consideration if a particular organization or group are considering to do this, to actually file an Amicus Curiae in a particular case. Then Anna explained to us the context of a country where this has been accepted now for almost 3 decades for the Constitutional Court, setting very interesting and strong jurisprudence, including with this idea of accepting the comments and the inputs of those that are not parts of the case but become amicus of the court in different modalities. And then Saba mentioning the specific work of media defense in acting as amicus curiae, particularly in the regional human rights system in Europe. So I think the participants have this overview. I guess that for the technical teams of UNESCO and the interpreters, since we started 10 minutes later because of the technical problem, I can go 10 minutes more because I see there are different questions in the chat, although Peter has been already working a lot in responding some of those questions. But I see that there are, regardless the specific cases, there are questions related to a few issues that maybe the three of you can comment. No one is in many jurisdictions, the amicus are not a possibility in the national justice system. No, so I guess some of the comments are more related to that. So if we don't have that in the national system, what's the next step? What we can do? We can go to the regional systems and so on. So I know it's difficult to comment without knowing the specificities, but maybe an overall discussion about these, where and when the amicus are not possible, what would be the next story? So this is one kind of question. There is another kind of question is, I'm facing problems in the judicial system as a freedom of expression defender, either I am a journalist or others, what I can do, to whom I can speak. So maybe Saba, you could take a little bit this question, explaining a little bit. Media Defense, of course, is one of the organizations helping with that, but how these people that are seeking for help, how they could engage, and what is your advice in this kind of circumstances, no? And then maybe a third element is a bit related to impacts and results. So, of course, we heard Saba mention one case that had a good outcome and so on. But overall, what is your, educated guess or maybe anecdotal evidence, although I don't think we have a study showing of how many amicus on freedom of expression that were filed in the last 10 years, how many of them had a good result or not, but maybe you can comment a little bit from your experience. Does this actually help? And then giving a little bit of context of that. So I think these three big questions could be our way forward. We have 8 minutes, so maybe I will ask each one of you to take 2 minutes to comment what you think you should comment, and then we can wrap up. So Peter, let's start with you, although as I said, you already started responding some of the questions in the chat. So over to you.
Yeah, let me take the question on what if the local legislation does not provide for Amicus Curiae briefs. That's difficult. I am aware of some countries where the local law doesn't explicitly provide for it, but organizations have been able to submit it, and that's the case, for example, in Indonesia. Similarly, in Malaysia, there is no legislation, but the courts there have developed the concepts through sort of successive cases, and of course there's always one that is then the first, so you can try and persuade the court in your country to be the first. I'm always a little bit positive, so I would say, well, if the local law doesn't say that you can do it, at least it doesn't say that you can't do it. So you can you can try your luck, as it were. You can also submit a brief by way of expert evidence with one of the parties. So that's another way of trying to get it before the court. I think what you really need to do is find a lawyer in your country that really understands your organization, what you try to do, and who can think with you of what will be the best way of doing this. But yeah.
Super, thanks. Anna, do you want to comment one or two of these overall questions we received on chat?
Yeah, I agree with Peter in that there, in most of the legal systems I know, even though there's not the figure of the amicus, there are procedural ways that you can fix that, or that you can introduce that type of intervention. So I think it's also being creative and showing local authorities, local judicial authorities, that it's not as different as other figures that they already have in their system. And I'm not going to talk about procedural law, because then the forum will be over. But it's important to understand that this is not as strange as it sounds. Even it has a special name, it's a Latin institution, whatever. It responds simply to the desire of the judge to wanting to be informed specifically on other issues that maybe him or her are difficult for them to get. It's a probation, it's an evidence issue, and you can, I agree with Peter, you can maybe try to introduce it that way, or promote legal change, which is also la respuesta más perezosa, the way of doing nothing. And also I think, well, in the case of Latin America, although a study would be very useful, maybe Guilherme could start that initiative of how the amicus have changed constitutional law in the world and freedom of expression in the world. But for Colombia, I think it has a huge impact. And constitutional judges, whatever their tendency is, even if they're liberal or conservative, or if they're with the government or they're not, they will tend most of the time to hear very strongly the interventions of prestigious international associations or international groups or international experts. I think that is a very, sorry to say, a very colonialist way of thinking about legal analysis, because sometimes you have the same argument of the expert, but just because the expert is saying it in English or comes from the UK or is different from our legal system, they tend to be more receptive to that argument. But in litigation, any honest strategy serves, and I think that is important. In Latin America, it has been a very important, rich mechanism to change the way constitutional judges view freedom of expression causes, and I think it's important to not only continue to expand the practice of Amicus Curiae, but also to share different ways of how they are doing it, even if the legal systems are different and sometimes not comparable. But for us in El 20 has been very reachful to be witness of how other organizations are doing it, and we have learned, and I think we have been successful in our cases when we have used this very important strategy.
Thank you. Gracias, Ana. Saba?
Yeah, I mean, I agree with everything that's been said. I noted the question specifically about international lawsuits and what can be done. Specifically to that individual, please do get in touch with Media Defence, and we can speak offline about specific assistance that we can provide potentially. But more generally speaking, you know, if obviously I know certain courts, certain regions have mechanisms in place that mean that you can access courts, and some don't have that. So for example, you have the Inter-America system, you have the African system, you have the European. Often, you know, with Asia or the Middle East, there are problems because there isn't a overarching international mechanism that you can kind of access, and as a result, you can't submit interventions. But there is potential to do kind of work still there. I mean, with Media Defence, we still are able to kind of engage UN mechanisms if there's a potential to do so. You know, use special procedures, etc. I think Peter mentioned this right at the beginning, but you know, having advocacy kind of campaigns, although that's not something Media Defence does, but those things can provide assistance more, you know, in terms of a general overview of trying to get an outcome for a particular individual or journalist. But yeah, and I also just saw a question about someone asking about judgment for the last case that I mentioned in my presentation. That's the case of Sanchez v. France. So the hearing in that was held by the Grand Chamber in June of last year, and we're still waiting on a date for the judgment. So as soon as that, I mean, you can find that on the European Court's website, but we've not been notified when that judgment will come out. The LuxLeak case, which I mentioned, that judgment is due to come out, I believe, on the 14th of February, which is next week. So the Grand Chamber should be issuing that decision. But yeah, I'm happy to kind of, I think I've posted Media Defence's details, but for anyone that wants specific assistance for individually for their cases, then please do get in contact with us.
Okay, super. Thank you, Saba. Well, time flies when we are having fun. And I think it was a fantastic 1 hour with this discussion. Very interesting questions in the Q&A. Also very interesting to see 100 plus people connected from all different regions, which shows again the interest of different groups in this discussion. From UNESCO, we do believe this tool, this guide, might be very useful and in a practical way to all of you. But together with our partners, including Media Defence, of course, we are open to see other ways we can support and cooperate and make sure that the judicial system is not used to harass freedom of expression, but on the contrary, is a concrete way of guarantee and protect freedom of expression that should be the main function of judges and prosecutors and others. So we do hope this discussion, this 1 hour webinar, but also the different tools that we have produced, including this guide, can be useful for all of you. So first, thank you very much for everyone who attended and took this time. Thanks a lot to Peter, to Ana, and Saba for your interventions, for preparing, for being short so that we could have a discussion at the end. Thank you very much for the Media Defence for co-organizing this with UNESCO, and thank you for our teams, Virginia, Oscar, Namara, the technical teams, the interpreters, for really making this possible. Without them, these kind of webinars, they don't fly. So thank you so much. Enjoy, have a wonderful rest of your day, and let's definitely keep in touch about this super important subject. So goodbye for now.